As already announced in the agenda, we'll now switch into English for the next panel, which is rather new to the Hohenheimer Tage des Migrationsrechts on the one hand, but shows and reflects a bit that migration law can't only focus on Germany and the German perspective and can't only focus on the European perspective, but should have a view beyond even Europe. So we hope that this experiment will work, and which means for the last part of this session, which will be question, answer, and comments, of course, German questions and comments are allowed as well, and we'll translate the questions. So please don't hesitate just because of the language. Root causes, closing of borders and asylum in third countries as lowest common denominator in Europe, which is the topic for this panel. Well, what does Europe do to itself and to other countries when Europe fosters any concept of protection elsewhere? Does it mean we follow a NIMBY approach, not in my backyard? Very happy to protect people, but not us, maybe others? Or is there something else behind? And what do we do to other countries, countries of flight, countries of origin, when when Europe tries to stop migration? And what should we look into? I will introduce the panelists in the order of the upcoming appearance. We will start with David Kipp, who is associate in the Global Issues Division at the Stiftung Wissenschaft und Politik in Berlin. He's working with his research on a project, Forced Displacement, Migration and Development, Challenges and Opportunities for German and European Politics. His recent research paper was on From Exception to Rule, the EU Trust Fund for Africa, and I think these few lines explain why David is start here. He'll be followed by Caroline Juki. Caroline has worked for over a decade in policy development and implementation on migration and forced displacement in the Horn of Africa. She's co-founder of the Africa Center on Displacement and Migration, ACDM. She was at the IGAD Regional Secretariat on Forced Displacement and Mixed Migration, and actually I do not have to go beyond to say why Caroline has to be on the panel here. She'll be followed by Boldizar Nagy. Boldizar is an associate professor at the, which university? At the Eötvös Loránd University in Budapest, which is probably completely wrongly pronounced.
No, it's Central European University.
It's a Central European University. He wants us to believe that he has reached retirement age. We don't believe it. He is one of these specialists of asylum law in Hungary. He has worked massively on this topic, not only under the current developments caused by the Hungarian government, but also before. And so he will help us to understand on a theoretical and practical approach what is going on in Hungary and why it might be going on in Hungary the way that it does, and what does it mean for Europe, and what consequences can we draw from that. And finally, in the order of appearance, we have Katerina Kutsopoulou with us. Katerina is a member of the Independent Appeals Committee in the Greek asylum system. She is a judge at the Administrative Court in Athens. She is not only a member of the International Association of Refugee and Migration Judges, but she is on the Council of the European Chapter. She has worked immensely on the topics of asylum. She has She's a member of the editorial team working on reviewing and updating professional development series developed by RMJ under contract of EASO. And finally, why do we have you here is that she was working on decisions, on the first decisions on whether Turkey was a safe third country under the so-called EU-Turkey agreement, and she will introduce to us the decisions of the Greek Council of State and her decisions and the way of reasoning why Turkey was finally considered as a safe third country by the Greek Council of State. So we'll now start, and I'll give the floor to David. I'm very, very keen on to hear what David will tell us about root causes and his research.
Thank you, and thank you for the invitation. Very happy to be here and also try to talk about root causes in this panel. I will do this in 4 steps. First, I will try to analyze the discursive function of root causes and also a dilemma that is posing policymakers in the EU and in Germany, especially development actors, when they use the term root causes. Secondly, I will show some figures on how development aid is allocated to support refugees and their hosts globally. Third, I will look at the EU Trust Fund. The study was already mentioned as an example of what is being funded and where the money goes to what end. And fourth, I will make some suggestions for the debate as well, how policymakers might be able to escape what I would call the root cause trap. So, as an introduction, we all know that since 2015, this figure or umbrella term of root causes and reducing root causes of forced displacement and migration, this varies, is something that goes along with the call for stronger border control. And the idea is, of course, to have preventive action. And I think language plays an important part in this because it suggests that the evil of unregulated cross-border migration movements can be tackled at its roots. So if you look at the research being done on this topic, of course, policymakers, they don't need research maybe sometimes to come up with claims, but if you check this claim, it's much more problematic and much more complex than suggested. Of course, migration and development have a very complex interplay, and actually when you look at research, it says, most research says that more development means more immigration until a certain point is reached, which is $7,000 to $8,000 GDP per person per year, which is a long time for many countries to reach. So this idea of root causes is not going to work so soon, especially if you don't consider other aspects that are important and are at play here, such as demographic pressures, the growth of migrant networks, the desire to reunite families, but also, of course, consequences of climate change. So development actors might be in the root cause trap here because, of course, funding comes along with this call of reducing root causes, but it won't lead anywhere if there's no real convincing strategy how to fight those root causes or how to reduce those root causes if we don't want to use this language of fighting. This is easier done when you talk about deterrence measures because deterrence logic often has a clear target, lowering arrival numbers in Europe. This is much more complicated when we talk about development in this context. Generally, development cooperation needs longer time, but I think it is very clear that this approach is more needed than ever as a result of the lack of responsibility sharing between member states or industrial states, I should say. And we all know that most refugees and IDPs are located in the south and not in industrial countries. So this brings me to the question, how strong is the willingness of industrial states to contribute financially to programs aiming at supporting refugees and their hosts if they're not willing to resettle more people to their countries? We see that there's an increasing number. This is a recent OECD study that was conducted. It's more a survey than a study. The OECD countries were invited to report their own numbers, and I know, for example, that the German numbers differ from the domestic numbers that are being reported, so there's some questions that could be debated about the correctness of these data, but it's a start, and we see that the ODA that is going to programs for refugees and host communities is rising. A lot of this is actually short-term funding, humanitarian aid, 70%. In total, between 2015 and 2017, the official development assistance that was given to countries hosting refugees was $26 billion US, which is, if I counted correctly, 23 billion euros, billion Milliarde. If we look at the allocation to specific countries, it's not surprising that the Middle East is leading. 35% go to countries of the ODA goes to countries in the Middle East, followed by African countries with 26%. And if you look at this list, it mostly matches hosting countries of refugees. Maybe one name is missing. Iran is also missing. Is also hosting a lot of refugees, which is not receiving much funds in this context. But the rest is more or less here. So we could say, this should be enough, but it's not enough, and we all know that. If we look at the numbers of underfunded appeals by humanitarian agents, I think UNHCR's budget was only funded by half last year, which is a historic low. And this money is especially missing in countries that are dependent on foreign aid, such as Afghanistan, Somalia, South Sudan, or Central African Republic. I'll still stay with this slide and offer some thoughts on how this gap might be closed. Of course, host countries are already closing the gap because they step in with their own financial resources in supporting refugees. In development terms, that's called providing a global public good, which is also the basis of financing countries such as Turkey or Jordan with development money. And I think this part is not recognized enough, that this call, which is also a call in the Global Compact for refugees to share the responsibility and burden, that this is not recognized enough, that what host countries are already doing. Another source for closing the gap might be non-traditional resources, so southern donors or other donors such as China, and also the private sector, which is a discussion I can't go into here, but this is when you go, for example, to development meetings on this topic, there's a lot of talk about private sector, and actually it's already contributing, but of course the money and the contribution could be higher. So basically this whole idea of development responses to forced displacement is of course also motivated by this gap, because hosting refugees in the way UNHCR did with its care and maintenance approach in the last decades is too expensive simply, and this is why refugees are economic agents in this logic now. It's not only motivated by altruism. So moving to the topic of the European migration policy, which is also the topic of this conference. I think in the German context, the root cause approach is maybe even stronger than in other European member states. But in November 2015, African and European leaders met in Valletta to establish the EU Trust Fund for Africa, which is also follows the same goal. And if we look at the implementation of this, of course, it's a little bit too early to talk about the long-term effects, but to make a midterm stock taking after the half of this is, I should say, an emergency instrument, so it's only planned to have this trust fund for 5 years, and we don't know what will happen after that. But if you look at the midterm results, most of the funding actually goes to more or less traditional humanitarian and development programs in sub-Saharan Africa and the Horn of Africa. These are relevant to European policymakers as countries of origin, but of course also as countries hosting a lot of refugees, such as Ethiopia. And in the last 1.5 years, the UTF strengthened its engagement very strongly in transit countries as well, such as Libya and Niger. And the most problematic example is, of course, the development funding that goes into the training and equipment of the Libyan Coast Guard. Right now, most funds are committed. This shows to which countries and subjects. And member states are right now debating whether to continue this instrument or not. And they're basically, most member states, also Germany, call for funds to be strategically used to have a direct effect on stemming irregular migration. And this is, of course, a problematic instrumentalization of development aid and goes to the disadvantage of less proximate countries, countries of origin, hosting countries, and we'll see if development ministries will be able to push back this attempt. I think this whole debate about this instrument also is important because right now the next multi-annual framework, the next budget of the EU is being negotiated, and here migration is a priority, and we'll see whether home affairs or development will be able to shape the instruments in the future after 2021. If I may give some suggestions at the end about the way forward, I think that in order to defend some of the human rights standards and also development principles in the heated debate over migration, we should first acknowledge the disruptive potential that this whole debate has developed. I was talking about language and images, and maybe that will also be a subject of the other panelists. And I think as a consequence of this 3 years of ongoing debate about people being at borders, images of mixed migration flows, we could talk about how to define that. But the result is that there's no distinction between refugees and migrants anymore. The terms have become interchangeable to the general public, and right-wing populists have created public distrust, and the ability to manage asylum and migration policy properly is doubted by a lot of voters. So that is why it is relevant to repeat this message over and over again, that migration and forced displacement need differentiated approaches, and also it needs realistic goals and strategies how to help countries that are hosting refugees, and of course also how to help those countries that are countries of origin, but not in such a one-dimensional way. We give you development aid and then people stop coming. This is certainly not the case. Promoting migration is at the core of the Global Compact for Migration, which provides an important multilateral framework And if I echo Angela Merkel's speech in Marrakesh, she said, the go-it-alone approach won't solve the issue. Multilateralism is the only way forward. So if Germany really picks up this credo and also wants to play a meaningful role for future global migration governance, it should start by defining a national implementation plan for the Global Compact on Migration. Thank you.
Thank you very much, David, for this way of giving us an in-depth view of what your work is and what your thoughts at the Institute are. And now we'll go on with Caroline, who will give us her view on, root causes and whether fighting root causes is the correct approach or fighting itself is the problem, and what whatever Europe means by fighting or states being addressed by asylum seekers like Australia, and what border management means.
Thank you so much, and allow me this opportunity to thank the organizers for inviting me. I do not have a PowerPoint presentation. I have a paper written in form of a journalistic piece. Not because I'm a journalist, but when you get to work on migration, displacement every day, then there are those realities that you'd like to piece together in an effort to truly communicate. Before I start, allow me to highlight certain aspects that the speaker before me alluded to, and that is we have observed still a reality of more interest in humanitarian funding than in funding for development. Please bear that in mind as I take us through my narration. And in the last up to 5 years, we've seen up to 30% of food ration cuts for refugees in the Dadaab camp of Kenya. So when the government of Kenya announced a rather controversial decision to close Dadaab, it was not a surprise to many of us, because their point was we are increasing vulnerabilities of people who are already vulnerable. And so it was really a rally to the international communities and all players to refocus more on, I don't want to use the term crisis, but to a situation of displacement that has already been going on for the last 2 decades. And just as a reminder, and one of the reasons I do not use the term crisis when speaking migration or displacement is that I come from a region, the Horn of Africa, that hosts more than 6 million refugees, and we've never called that a crisis. The private sector is important as we speak about the development nature of addressing displacement alongside, of course, humanitarian action. And it did not escape many of us that the refugee chief was in Davos and so many humanitarian actors appealing to that very crucial segment of society towards investing more in refugees, because that's what they are calling for. And finally, these are just my tidbits, is on the EUTF and Valletta. As the speaker before me mentioned, it's still too early to really say what the impact of these is, but on the ground, even before any monitoring or evaluation has been done, is that many African countries are quite disappointed. But again, from my point of view, there is a feeling on the ground that the African countries have also not been very serious about the commitments they made in Valletta. On to my paper, and I call it Addressing Root Causes of Migration and Externalization of Borders, an Implementation Fallacy. An intergovernmental conference took place in December 2018 in the beautiful Moroccan city of Marrakesh and adopted the Global Compact on Migration, or the GCM, as it has come to be fondly called. Against this background, the New York Times reported on 6th December that the migrant crossing through the Red Sea has seen a significant increase, more than the crossings and arrivals in Europe through the central Mediterranean. This is backed by migrant flow monitoring conducted by the UN Migration Agency, IOM, using their collaborative data collecting tool known as the Displacement Tracking Monitoring. I read this on my way from a small dusty migrant city of Obok in Djibouti, probably the biggest part of the puzzle in the migration flows on the eastern route to Yemen, and therefore the New York Times reporting did not come as a surprise at all. The Horn of Africa and agencies that work in that region have long engaged, collected data, and analyzed trends and communicated the realities of migrants, often mixed, who take the journey eastwards. And when I talk about mixed migration, it's because in a group of people that are moving, they have all sorts of reasons as to why they left home. And that also explains the graying of the fact whether one is a migrant or one is a refugee, and we see a lot of that. We see refugees who leave Kenya, Ethiopia, because there are no opportunities, and then turn migrants on their way to Europe. The biggest of the numbers on the eastern route, up to 92%, are young men of up to 25 years from Ethiopia. It's not a country in conflict. Somalia follows closely with only a few Eritreans on the route. And I'm aware that Eritreans are one of the largest number of asylum seekers in Germany from the Horn of Africa. Whereas Somalis receive prima facie recognition and grant of asylum in Yemen, the same does not apply to Ethiopians. Many will actually not be seeking asylum, stating clearly that the reason for embarking on this perilous journey is largely economic. There are different crossing points towards Yemen. It's in Puntland region of Somalia, Somaliland, but the most significant is this tiny dusty town called Obok in Djibouti. Just before Christmas last year, I drove from Djibouti city through Tajura into Obok, a distance of 328 kilometers. And so young men walking along the tarmac on the incredibly harsh terrain and temperatures of up to 40 degrees Celsius, often without water in the scorching sun. They keep closer to the road with the hope to get the occasional hitchhike, water from travelers and neighboring settlements, and as protection from animals and any other threats that may be found more inland, of which the rough terrain would be enough for most of us. Often their journeys are facilitated, as they choose to refer to smugglers, and the transportation is a mix of long treks and use of private and public transportation. One young man told me that he paid an equivalent of $1,000 or thereabout for his journey up until Djibouti from Ethiopia. If one makes it there safely, and many often die in the dry conditions due to starvation and dehydration, the wait for smugglers, or facilitators as they call them, to enable their onward crossing by boat to Yemen begins. There are those whose families will support their dreams by paying for the crossings. Migrants I spoke to in Obok during the trip reported that 45 of those they had left home with had departed the previous night by boat, since their families had paid the money to the smugglers. They were waiting, hoping, and trying to make some money to raise the required further up to $1,500 for the crossing for what is a 3 hours boat journey. While to the authorities and the rest of us, smugglers are criminals engaging in transnational organized crime, the migrants see them as the facilitators and a bridge to their dreams. They provide a service, a much needed one at that, despite reports of torture, including throwing migrants overboard on approaching the shore, electrocution, as was recounted to me by a 13-year-old evacuee from Yemen, and a few years back, kidnapping for organ removal. Many of these migrants speak to a lack of any perspective for the future, indicating that the amount paid for the journey of up to $2,500 is a necessary investment. Are they aware of the dangers? Absolutely. They have heard from those who went before them, have previously experienced themselves, as is the case of a migrant who reported having just been deported from Saudi Arabia 3 weeks before our conversation and was already back on the trek. Why? I asked him. On his previous attempt, he had found employment on the Yemeni-Saudi border, trading in khat, a nicotine-filled chew herb popular in Yemen and Saudi Arabia. He claimed to have made up to $1,000 per month and had been rounded up in the ongoing crackdown on irregular migrants in Saudi Arabia and deported. He therefore could not see any other way of getting the kind of income he was making before his deportation. Asked if he was willing to be assisted to return home, he feared that he had nothing to return to. We spoke to the possibility of support towards establishing a business or training towards a skill that can help him fend for himself and his family. That had him thinking and speaks to the need to truly address reasons of flight, which often include a lack of hope to improve one's situation in the present and future. Stringent border control by itself will not offer a solution to the governance of migration. As a matter of fact, it has only made migration more dangerous and left the smugglers with more money in their pockets. This is reported by migrants on their journeys to the Middle East and northwards towards Europe. Withdrawal of life-saving vessels in European waters, very controversial, may have seen a slight drop in arrivals on Europe's shores for now, while at the same time making smuggling more lucrative, more lives lost, and more people in deportations in countries that are unwilling or unable to uphold protection of human rights. This against a continent and humanity that speaks to standing up for human rights. Some of the current collaborators on the African continent on migration control, in quotes, are states that are known for blatant human rights violations against their own people. But on the migration front, partners look the other way and engage them as gatekeepers. Another reality is that the other migration routes, for instance, that down to South Africa or Yemen and Saudi Arabia, have seen a considerable increase on numbers against a European crackdown. For perspective, the fact that there is an ongoing conflict in Yemen has not acted as a deterrent for migrants destined there or transiting towards Saudi Arabia. The responses that address such a deep-seated risk-taking has to be convincing, almost life-changing. It has to involve families while addressing structural issues that contribute to the lack of access to livelihood opportunities, addressing conflicts for a significant number of young people, mostly men, in the Horn of Africa where I come from. Border patrols alone, and I keep repeating this, will not address the challenge of irregular migration towards Yemen or northwards towards Europe. Addressing the individual, community, and structural drivers of migration is ultimately the better way to address irregular migration in a sustainable manner. This requires collaboration and partnerships with more than traditional migration actors, which are, where I come from, ministries of interior. This should include local and international development actors, peace and humanitarian actors. The desired outcome will not happen overnight, but over time. We have the potential to move towards more safe, orderly, and regular migration that benefits the migrant, communities of origin, and those of destination. A drop in numbers by itself of arrivals is not enough, nor an indication of a human rights-based migration governance regime as espoused in the Global Compact on Migration. The GCM therefore presents countries with opportunities to cooperate to address irregular migration as well as facilitate orderly and safe migration. This global, non-binding framework is being seen by many, especially in Africa, as having the potential to create more partnerships, strengthen data collection and application by governments in making evidence-based policies and ultimately contributing to the attainment of the dream of the Sustainable Development Goals of truly leaving no one behind. I thank you for your attention.
Thank you very much, Caroline, for this very impressive insight into what happens when borders are closed and what happens when people need to be smuggled or facilitated. Now we'll move on farther north to Eastern Middle Europe and Hungary and Bolivia. The floor is yours.
Sehr geehrte Damen und Herren, Kollegen, Freunde, Sie müssen mich entschuldigen, weil ich nicht in der Sprache benutzen werde, die so schöne Ausdrücke hat wie abschiebungstypische Vollstreckungsmaßnahme. So allow me to follow in English, and I also apologize, I haven't written down my talk. I only do that when I'm burying someone, and we might have dug the grave of democracy, but we are still not burying it. So it will be oral. And a few further remarks. My talk will be uploaded to my website. So just listen to me as if there were no slides, and I will guide your attention to the slides when need comes. I plan to attend 4 issues. One is the order of magnitude, then a bit of a theoretical frame, then to explain what happens to Hungary, and then to explain what happens to the Visegrad 4 countries, including the Czech Republic, Poland, and Slovakia. And time permitting, which usually doesn't, we might return to the issue how the EU as such should respond to the situations. So really listen to me. Those of you who can share attention, of course, are welcome to look at the slides as well. This is a quote from the Prime Minister of Hungary then and now, Viktor Orbán, at that time, 2015, speaking at a large UN gathering, basically calling for a global quota system. Now, those times are gone. These are two images from the election campaign and the summer of 2018. As you will know, the remarkable similarity with another great power not within the continent. There, America is first, here, Hungary is first. That was the slogan of the Minister for Defense running for re-election. Guess what? He was re-elected. And the other slogan refers to the Global Compact on Migration without using that expression, saying that the UN wants us to continuously receive or settle into Hungary migrants. Hungary decides, not the UN. To make it very clear, this is a quote by the Hungarian news agency, quoting the Minister for Foreign Affairs, Péter Szijjártó, saying, and now you are welcome to read it, the reasons for the attack against Hungary is that the country's position on migration is at odds with the European mainstream. The minister continued confirming that Hungary will not be an immigrant country and does not support the changing of the makeup of the population of the European continent, and accordingly the government rejects the system of mandatory quotas. So here we have all the motivations, the leitmotifs of the Hungarian refugee policy, asylum policy. Now, concentrating more on the precise topic of this talk, which will not be very legal. I do legal work. You will find an extensive bibliography at the end of the talk, where you will find my pieces also in German, which are boringly legal, as it is welcome in some parts of Europe, very positivist, if you want. This talk is addressed to a broader audience. So I assume you know what the EU policies are. I won't talk about that, except for the last section. I take up a number of issues. First, I try to explain why Hungary does what it does. Second, who drives that policy? Is it population-driven or is it government-driven? And then we turn to the Visegrad 4 countries. As I said, it will be uploaded by afternoon at my website, which is my name, nagyboldizsár.hu. And finally, the possible outcome at a European level. Orders of magnitude. What I draw your attention to is that since 2015, before and after, there were significant differences, both in the numbers of arrivals into the Visegrad 4 countries and in the composition of those groups. Here you see the total numbers of arrivals, where it seems that Hungary really had a lot applications, but that's not genuine. These people did not stay for more than 1 to 3 days, which is stressed, underlined by the fact that the actual decisions giving protection to someone, recognizing someone as in need of protection, are not that high at all, 505. And so it goes, and by now, numbers have gone down. Hungary has 516 applications, or had in 2018, of which 350 were recognized as in need of protection. The reason, of course, is if you detain persons, then they have to stay and they have to wait until the end of the outcome. Even in 15, the composition of the arrivals was very different, whereas Hungary had 64,000 Syrians recording their application and 45,000 Afghanis. The Czech Republic, Poland, and Slovakia had different constituencies and much, much smaller numbers in 15. This is the most recent statistics available, covering the third quarter of the last year. And as you can see, the Czech Republic and Poland mainly receive asylum seekers from the post-Soviet area, whereas Hungary has a kind of an EU parallel, and Slovakia is semi-exotic with really small numbers. How do these countries speak, nevertheless? This is a quote from the summer of 2018, a meeting of the Visegrad countries. Now, it is subject to a bit of linguistic and legal analysis. First, they say, we believe that the countries of the European Union, so they're not speaking about the European Union, they want to carve it up into member states, divide and impera, should seek to establish an asylum system that takes into account the real needs and capacities of our societies. Now, ladies and gentlemen, those of you who work with refugees, you do know well that this is not a utilitarian project. It doesn't matter what the societies need. What matters is whether there is a need for protection or there isn't. That's totally irrelevant to say that asylum systems should be dependent on the needs and capacities of the societies. And the commitment of our countries to national sovereignty, asylum seekers and refugees have nothing to do with national sovereignty. They don't affect it in any manner whatsoever. We are convinced that an effective return system is an integral part of a comprehensive migration management. Refugees, no, return system. They move without hesitation from protection or instead of protection to the return system. And then they state that any compulsory allocation system is not acceptable. So that's where the Visegrad countries stay, even though the factual basis was and is very different. Now, what is the theoretical frame within which I move? It is characterized by 3 strands. One of them is securitization. Here I summarize what I mean. But if you go to my slides and you print them in notes pages format, below the actual slide, you will find real quotes from the authors, for Jeff Huysmans, for example, or Gábor Bernát and Vera Messing, who speak about how securitization occurred, with more precise references which you find here as well. So securitization basically means that there is a speech act by the securitizing agent, in our case the government, in your case the AfD, for example, which says there is a specific threat threatening the survival of the society, and here I am, the only one who can address that threat. But since I do address it and I'm saving you, you have to give me the liberty to deviate from the law, to not apply the law, to interpret it in a very specific way, to have exceptional empowerment. Oh, sorry, that was not my intention. This was my intention. The second frame is majority identitarian populism. Basically, a populist actor which claims to represent the majority and the identity of the majority speaks of the other as threatening that identity. That other might be Brussels, the Commission, the bureaucrats in Brussels. That other might be a national or ethnic group. In our case, usually, this was the elite in Brussels, not the local elite in the countries, because the local elites were the populists who were finding the other in the elite of Brussels. And the third strand is discrimination, a scholarly approach coming from the United States of America, which basically highlighted how criminal law and immigration law was pushed together, how migration and immigration was regulated and in an increasing fashion by criminal law tools like detention, and also how criminals were in an increasing fashion punished by migration tools like expulsion. So this is the framework in which I interpret what happens in Hungary and in the Visegrad 4. So we have moved now from the theory and the orders of magnitude to Hungary. Visegrad 4 will come and then the end. I claim that what is happening and what has been happening in Hungary for the last 4 years by now may be interpreted along the lines of 4 categories. And again, in the notes pages, you will find a detailed description of what they mean, taken from a presentation I had at Berkeley this last fall. But I have developed that at great length in different publications, including the German Journal of International Law published in the United States of America. First, I claim that Hungary is in denial. And that, first of all, means that it never speaks about refugees. The government never utters the words refugees. It's always migrants. But it also denies that the NGOs assisting refugees or asylum seekers are acting in harmony with international legal obligations, essentially performing a task what the state should perform in receiving, supporting, giving psychological support, and so on and so forth. It denies the benefits of regular migration as well, to extend denial. Second, deterrence. Of course, the fence built up in September and October 2015, first with Serbia and then with Croatia, was the classical tool of deterrence. But we have 4 forms of detention of forced migrants and others. We occasionally, not we, but the government, occasionally was starving asylum seekers in closed detention centers. They stopped due to the intervention of the European Court of Human Rights, but those who had the repeat application would not get food, but they were not allowed to leave the transit centers either. And of course, the whole civil sector is stigmatized first by the rules on announcing that you are getting foreign support, and now by being threatened by a specific tax, and by having criminal threats to which I will return. The third is obstruction. So if the people could not be deterred from coming, then they're obstructed in getting access to the asylum procedure, partly by the safe third country rule being applied to Serbia, partly by introducing a new admissibility ground, which is much softer than the safe third country, basically entitling the authorities to remove anyone to any country where the person would not be killed, so to say. We have a great number of accelerated and inadmissible procedures, and we have the most absurd system, only to be compared with Australia. That is, the government has announced there is a crisis situation caused by mass migration. This is not true, not even according to the criteria of the law which introduced the institution. Nevertheless, it has been announced and repeated every 6 months. Now it is in force. The consequence of that is, remember securitization, that not the ordinary rules on refugee status determination procedure are applied, but a specific system. That specific system entails that anyone who is caught in the whole territory of Hungary and claims asylum, claims to be a refugee, is by force taken to the Hungarian-Serbian border. The fence, pushed over the fence where there is a 3-meter wide Hungarian territory, beyond that is Serbia, and expected to walk up to the transit zone and apply from the transit zone. But the transit zone only takes 1 application per day, and there are 2 transit zones. You laugh, we started to laugh when we saw that was an idea. It's totally tragic. So people are forced to irregularly re-enter Serbia and wait there for weeks or months. So that's, if there is obstruction in the globe, this is obstruction. Punishment. First, it criminalized asylum seekers coming across the fence. It threatened with criminal imprisonment, imprisonment with criminal charges. Second, in this year, last year, 2018, it introduced the crime aiding and abetting illegal migration, which was very widely condemned by the Venice Commissions and others. It bans even the inhabitants of a certain stripe next to the border, 8 kilometers, may be banned from returning to their own home if they are found to be aiding and abetting illegal migration. The third one is no solidarity with the EU. We had been waving through 400,000 people through Hungary. in 2015, and now Hungary is denying any relocation or resettlement whatsoever. So that's a classical expression of the lack of solidarity. Hungary does not even perform under the Dublin rules. Breaches of law are very widely perceived. On the one hand, obviously, we are in breach of a number of regulations of the Geneva Convention, primarily Article 31, but also Article 33 on non-refoulement. There are 4 pending infringement procedures against Hungary related to migration. And it endangers hatred with all the measures against the migrants and asylum seekers and refugees and the NGOs as well. So, who drives that policy? It is not the population. It is not a government response to the population's demand. It was produced by this discourse engendered by the government itself. And that has been amply shown here. You have one reference which shows that not only in Hungary, but also in the other Visegrad countries in 2015, like in Czechoslovakia, or the Czech Republic, and Slovakia, where practically there were no asylum seekers, the perception that migration is one of the 2 major problems of the country have skyrocketed. Another quote from the friendly Czech television from the Prime Minister, Orbán, from November. Read it for yourself. You have 20 seconds because I only have 3 minutes left. And we have now to come to Visegrad. Any populist textbook can rely only on Hungarian public statements. No need to search for anything else. Assuming you have read it, okay, that's the description of the crime. I can skip that. And here we come to the Visegrad 4. Especially Hungary was frequently stressing that it's not alone, it is part of this lovely group of the Visegrad countries, the Czech Republic, Hungary, Poland, and Slovakia. But is it so? I believe it isn't. This is an overall table showing a few crucial issues like rule of law procedures, rhetoric on the EU, core EU, attitude towards Russia, attitudes towards Germany, posted workers directive, or the most recent one, the European Public Prosecutor's Office. As you can see, the Visegrad 4 are fairly divided. There's more similarity between Slovakia and the Czech Republic, and more similarity between Hungary and Poland, but for example, on the stance towards Russia, they are antagonistic, absolutely. Coming to the asylum issues, the Visegrad 4 were against the relocation decision of 2015, but not all of them did sue the Council, claiming that it was adopted in an illegal fashion. Hungary and Slovakia did, and Poland later joined after the government change joined. We know well that the court bashed the countries. They said this is nonsense, nonsensical arguments were produced, so the relocation decision is valid and in force, and therefore now 3 of the 4 are subject to an infringement procedure started by the Commission for not having performed under the relocation procedure. This is a chart you might wish to study at some length. It's about the 2 global compacts. Now, if the Visegrad 4 were one bloc, they would have voted in the same way, or the stance would have been the same. It wasn't. As to the Global Compact on safe, orderly, and regular migration, as you can see, the Czech Republic, Hungary, and Poland were against, but Slovakia wisely did not participate. In the case of, and the foreign minister stepped down as a protest against the intention of voting against, and then he was reappointed again. And I do understand, Chair, that I have a minute and a half, and I will finish within a minute and a half. As you can see in the concerning the Global Compact on refugees, the Czech Republic was in favor, Slovakia was in favor, whereas Hungary, among a small company of 2, itself and the United States, we surely will believe that we are great powers. If we are always with the US, we must be great powers, well, must be not. So we voted against, and Poland did not participate. Is there a common denominator then between the Visegrad 4 and the EU? I don't think so, not in asylum matters. I mean, the positions of the 2 blocs are diametrically opposed, whereas the EU wants an integrated border management, Hungary and the V4 countries want national border management. Whereas the EU policy, recognizes that those who reach the territory of the EU are entitled to protection if they are in need of protection. The V4, but especially Hungary, denies the existence of refugees. The EU goal still formally is an EU-wide asylum policy with common procedures and uniform status. The V4 and Hungary claims national treatment of migrants. The EU calls for solidarity. The V4 call for fighting migration at a national level, absolutely no relocation and no resettlement. And here we are at the end of my talk, conclusion, demise or solidarity. Now, think of this question. Why would Lebanon be more responsible for taking up Syrian refugees than Hungary, Italy, Finland, or Germany? Is there any moral ground which would say the country that is closer is morally more responsible? Unless you can show one, the whole externalization project fails. So what the EU does now is not what it should do, and there I'm really coming to the end. I believe that the EU should see itself as a unified protection space. I believe that it should introduce significant resettlement quotas and humanitarian visas, just as proposed by the European Parliament. It should contribute more to stopping the crisis in the countries of origin. There's no crisis in Europe except for the crisis of the law and the institutions. There's no refugee crisis. Refugee crisis there is in, let's say, Lebanon or Turkey, or you might have said, Caroline, that in your regions there are. And it should keep open and open up new routes for regular migration and only return them who have no right to stay. And this might be my last slide. That is, how could that be done? Either decision-making could be done at the EU level, and there are proposals for them. For example, one of the most famous German professors, Guy Heilbronner, said so. Guy Goodwin-Gill is of the position that decision-making could be done at the EU level, or national level decision-making with intensive participation of the EU staff. A Dutch team had that proposal, Carrera and Lano. Or one could buy into this flexible solidarity argument, saying, all right, the asylum seeker chooses the land in which she or he stays, but the costs are to be borne together. Ladies and gentlemen, was it a great privilege to speak to you this morning? Certainly it was. Thank you.
Thank you, Baldassar. It's a great privilege to have you here and have the privilege to listen to you and your explanations on how Visegrad is functioning and whether Visegrad is really a block of countries or more or less an idea of countries you might like to be a bit like each other. So now we head forward to the last presentation of this panel. Katerina and Turkey as a safe third country, or safe third country as a concept. So please, Katerina, the floor is yours.
So, hello. I'm very honored to be here today. I always feel home whenever I come to Germany, because I believe that the last years our countries are very, very connected. It all started with the economic crisis, but again, then we had the refugee crisis, because both in Germany and in Greece we call it crisis. Perhaps we feel it as a crisis. Today I will present you the safe third country concept and its interpretation from the Greek courts, especially after the EU-Turkey agreement. Now, the preamble of the Refugee Convention acknowledges that the grant of asylum may place unduly burden on certain countries, and that a satisfactory solution of a problem of which the United Nations has recognized the international scope and nature cannot, therefore, be achieved without international cooperation. One of the expressions of international cooperation among states is the adoption of international agreements that implement the safe third country concept, whose lawfulness is presumed on the grounds that protection has already been found or can be found elsewhere. This concept expresses the principle of subsidiarity of protection, where and if and when the applicant was already safe in another country or has strong connections to another country. In Europe, the safe third country notion is enshrined in Article 38 of the Asylum Procedures recast, which describes the treatment of persons seeking international protection in accordance with specific principles. The consequence of safe third country is that member states may consider an application for international protection as inadmissible, that is to say, to reject the application without examining the substance. Article 38 provides 3 steps for the application of the safe third country. First, the member states may send applicants to third countries with which the applicant has a connection, such as that it would be reasonable for him or her to go there. Second, the 5 criteria in paragraph 1 have to be met. And the third step, it is required to have rules in accordance with international law, allowing an individual examination of whether the third country concerned is safe for a particular applicant. The applicant can challenge the application of the safe third country on the grounds that the third country is not safe in her particular circumstances. And also the applicant has to be allowed to challenge the existence of a connection between him and the safe third country. Now, the criteria in Article 38, first of all, in the third country, the applicant's life and liberty must not be threatened on account of race, religion, etc. He must not be at risk of serious harm as defined in the Qualification Directive. He must not be at risk of refoulement, and he must not be at risk of persecution or treatment in violation of Article 3 of the Convention of Human Rights. And in that third country, the possibility exists to request refugee status, and if found to be a refugee, it must be possible for him to receive protection in accordance with the Convention. Now, one of the most recent examples of the concept of safe third country was the agreement between the heads of the state or government of the European Union and Turkey, set out in the EU-Turkey Statement of 18 March. According to this agreement, all new irregular migrants crossing from Turkey to the Greek islands will be returned back to Turkey. But what legal basis? What is the legal basis? In Greece, there is no safe third country list. Therefore, it was agreed that people who apply for asylum in Greece will have their applications treated on a case-by-case basis in line with the EU and international law requirements and the principle of non-refoulement. There will be individual interviews, individual assessments, and rights of appeal. No blanket, no automatic returns of asylum seekers. The asylum applications will be examined under the safe third country concept and will be rejected as inadmissible if the conditions are met. So immediately after the conclusion of the agreement, the Greek Asylum Service, the first instance, started the application of the concept in the context of the fast-track border procedure under national law. And by the end of 2016, only applications lodged by Syrians nationals were examined under the safe third country concept, and still only Syrians. So on August 2016, the first appeal against the admissibility decision was brought before the newly established independent appeals committees. It's a tribunal composed of 2 judges and a member indicated by UNHCR. And the applicant challenged the first instance decision on the basis that the conditions of Article 38 are not met in his case, and therefore Turkey is not a safe third country for this applicant. Now, in order to better understand the way the Greek courts had interpreted Article 38, I think it's worth mentioning the facts of the case. the applicant was a Syrian national. He stated that in his first attempt to pass the border with Turkey, they were divided in two groups. The group in front of them had received fire from the Turkish police, but in his second attempt, he passed the border with Turkey on foot with the help of a trafficker and without facing any problems. He stayed in Turkey for 2 months. He was fingerprinted but didn't issue any documents. He didn't want to issue any documents from the Turkish authorities and didn't contact them. He also tried to enter Greece many times, but during his second attempt, the Turkish Coast Guard arrested him. He was kept for a few hours in a place with animals and rubbish, but didn't face any other problems. He further stated that he didn't apply for international protection in Turkey because of the political situation after the attempted coup. Specifically, he stated that he has heard from his friends that the situation for the Syrians became worse. There was no protection. The Turkish police invaded Syrian houses and forced them into the street. The Turks were not interested in the security of the Syrians. Then, he also stated that he personally didn't face any problem in Turkey with the Turkish authorities or any other state organ, and that there's nothing specific to fear in Turkey. He had no other reason to fear return to Turkey, but he prefers Greece and he prefers Europe. So these were the facts. The starting point of the interpretation was how the judicial control will be exercised in Article 38. So in order, the committee noted that in order to determine whether a third country is safe, the national authorities should carry out a control conducted in 2 stages. In the first stage, the authorities should investigate whether, in view of the general social, legal, and political circumstances of the third country, the conditions of Article 38 are fulfilled. And consequently, the third country can be considered safe in general. Should the national authorities have established that the third country is not safe in general, then there's no need to go to the second stage of control. So it's only when the safety of the country has been established in a general level that the authorities proceed to the second stage, and only if the applicant claims that the third country is not safe for him particularly, having for this purpose a special burden of proof. And in case when after the individual assessment of the applicant's claims, the authorities consider that there are valid reasons for the country not to be safe under the specific circumstances for the applicant, then the characterization of the country as safe can no longer be valid. So 2 stages, general level, and then very individual assessment. Also, in these particular cases, before the court, before the appeals committee, various informations have been provided, among which there were letters from the permanent representative of Turkey to the EU, where the former assured that Syrians returning to Turkey from Greece will have access to temporary protection. Also letters of the DG Migration and Home Affairs of the European Commission to the Greek authorities, where they were stating that the safe third country can be applied because Turkey provides all the assurances to Europe, to the Commission, and to Greece. Also a letter of the Commissioner for Migration, again to the Greek authorities, stating that despite the attempted coup, the Turkish assurances remained valid. And also special consideration has been given to letters by UNHCR, and that was really interesting, because UNHCR noted that all the Syrians who had returned to Turkey from Greece would prima facie had access to temporary protection based on the Turkish ambassador's assurances, and also in other letters, UNHCR had informed the court that had conducted three visits to the reception center of Dudici, where Syrians returning from Greece would complete pre-registration procedures. UNHCR assured the Greek authorities that 2 of them have left following their arrival to be reunited with their families, 9 decided to voluntarily return to Syria, and 7 completed pre-registration procedures and were reunited with their families. So all this together, the appeals committees deemed that these particular letters from the Turkish ambassador, the content of which was confirmed by all the other letters and other informations from the websites or from EASO, constituted diplomatic assurances of a particular evidentiary value. And finally, after assessing the circumstances of the case, the committee rejected the appeal on the basis that Turkey is a safe third country for this particular applicant. So immediately an appeal was lodged before the Council of State, it is the Supreme Administrative Court in Greece, and the case was referred to the full plenary. The full plenary consisted of 36 senior judges. The Council of State had rejected the appeal with 2 judgments, number 2347, 2348. And there was only a dissenting opinion of 2 judges out of 36. So, first of all, let's start by the EU-Turkey statement and the Council of State. Now, the appeals committees had found that the EU-Turkey statement was legally binding and valid. However, the Council of State didn't refer to the validity of the statement, but agreed with the appeals committees that the applicant's claim was dismissed as inadmissible on the basis of the safe third country concept and not the EU-Turkey statement. So, according to the Council of State, the EU-Turkey agreement was not important for our cases in Greece, was not important at all. Also, the Supreme Court dismissed the applicant's submission that the content of the letters was unlawfully not disclosed to him during the examination of his application so as to enable him to rebut them, since the applicant, both in the first instance interview and in the appeal, had expressed his views regarding the situation prevailing in Turkey and the policy of the Turkish government vis-à-vis Syrians who seek protection there. Now, as to the first criteria, threat to life or freedom, the Council of State found that there is no threat to the applicant's life or freedom for reasons related to his Syrian origin, and that the incidents of violence occurring during his attempt to enter Turkey from Syria do not give rise to a risk for his life, also in view of his stay in the country for 2 months without any problems with the authorities. In relation to the general situation in Turkey following the attempted coup of 15 July 2016, the court relied on the committee's view that the available information, namely the letters of the commissions, etc., suggested no change in the protection offered by Turkey. It also found that the applicant had failed to demonstrate that he would be individually targeted by the Turkish government. As regards the serious harm, the Council of State noted that the allegations of Turkey's practice of administrative detention of Syrians returning from Greece were unsubstantiated. The court rejected an argument raising the risk of a violation of Article 3 on account of detention and living conditions in the country, on the ground that this assessment falls outside the competence of the Appeals Committee. As regards refoulement, the position that Turkey does not respect the principle of non-refoulement in practice was also dismissed as unfounded, relying on one hand on the large number, 2.75 million, of Syrian refugees in Turkey, and on the other, on the diplomatic assurances provided in the letters of the EU and Turkish officials. As regards the in accordance with the Geneva Convention, that was a very interesting position. The Council of State agreed that when interpreting the concept of protection in accordance with the Geneva Convention, as not requiring the third country to have ratified the Geneva Convention, and in fact without geographical limitation, or to have adopted a protection system which guarantees all the rights foreseen in that convention. This reading was made through a juxtaposition of the safe third country concept, Article 38, with the European safe third country concept, Article 39, which expressly requires to the third country to have ratified and respect the provisions of the Geneva Convention without geographical limitation. The court further explained that the Geneva Convention does not foresee uniform protection of all persons falling within its scope, since on the one hand, its rights are differentiated depending on the degree of connection of refugees with the host countries, and on the other hand, most of the rights foreseen may be restricted by way of reservations upon signature, ratification, or accession to that convention. The last was the connection. The court found that the applicant's stay for 2 months in Turkey and its proximity to the country of origin established a sufficient connection and made it reasonable for him to return there. The Council ruled that an applicant's transit from a third country may be in conjunction with specific circumstances applicable to him, such as the length of stay in that country or the fact that the country is located close to the country of origin, be considered as a connection between the applicant and the third country, based on which it would be objectively reasonable for him to be relocated there. In paragraph 62 of the judgment, the Council notes that accepting the opposite would run contrary to the very aim of international protection of refugees, which is their immediate protection by alleged persecutions in their country of origin, and not the possibility for them to choose which European country will afford them the best possible conditions, thereby turning persons in need of international protections into migrants, as in persons who leave their country of origin in search of better living conditions. Also, a majority of 13 to 12 judges found there is no reasonable doubt as regards the meaning of Article 38 of the directive, and thus no reason to submit a preliminary reference to the Court of Justice of the European Union in accordance with Article 267 of the treaty. Now, finally, we're 3 years after the EU-Turkey statement. The deal has been portrayed as a success due to arrivals of refugees in Greece allegedly falling by 90–70% compared to the period preceding. Now, according to UNHCR and the Ministry, in 2016, the sea arrivals in Greece were 173,000. In 2017, only 29. In 2018, almost 32,000. And up to now, they are 489. So the arrivals have been done. Now, as regards the applications, in 2016 we had 51,000 applications, and in admissible decisions there were only 1,300. In 2017 we had 58,000 asylum applications and only almost 900 inadmissible decisions. And in 2018 we had 66,000 applications and only 400 inadmissible. And in total, since 2016, only 322 Syrians have been returned to Turkey, and 33 of them have been returned on the basis that their asylum claims were found inadmissible at second instance. So only 322 Syrian cases after the EU-Turkey agreement, and only 33 after the appeals committee's rejection. Therefore, we can easily assume that the EU-Turkey agreement has provided the opportunity for an in-depth analysis of Article 38, has provided the chance of an interpretation to the Greek courts, even though someone can argue that since the case is presenting a great opportunity for receiving insight by the CJEU, we lost a very wonderful opportunity for that. But no one can doubt that the arriving migratory flows have significantly decreased, but given the fact that it has resulted in the confinement of a large number of applicants in the Greek islands, and that the number of returns that have been actually implemented is still extremely low, someone can argue that its real effect for Greece was never significant. Thank you very much for your attention.
Thank you, Katerina, for this insight in the process of the judicial review of one part of a cornerstone of the European approach to the strengthening of an external sea border without any prejudice to the assessment of the political impact of this act of strengthening the border. On the other terms, as it was yesterday, State Secretary Gebers who said on one point, and that's a success, if you can call it a success, which means politically you never know what a success is and what a failure might be, but it works at least as it should work, as we see from the numbers, and it was intended to be. We have just a few minutes left, but 2 to 3 questions could easily be allowed. Yes, please.
Hi, Maike Riebau, Save the Children Germany. Thank you so much for all of these presentations. I have 2 comments and a question for David Kipp and Ms. Nuki. I hope I'm not butchering up your name. Thank you, David Kipp, for providing us with some data in terms of the finances. I think that's a much needed addition to the debate. I'm skeptical, like you are, that these are actually accurate numbers. So I don't know if we will ever know for sure. One thing to add from someone who works in one of these organizations that is active throughout the world, I think we also have to count in not only the ODA but the humanitarian part, because as we see more and more the humanitarian crisis and development aid programs merging into each other, under the buzzword protected crisis. I think that, I don't know if that's something to look at in another project. And to you also for providing us with insights from the migration routes themselves. I think that's also very helpful. Do you happen to know if there are like child-specific protection gaps or someone who's looking at child-specific protection gaps? That would be helpful to know. So, thank you.
Do we have any other questions? Don't see anyone, so... Oh, there's one in the back. Yes, please.
Charlotte Fiala, Humboldt-Universität zu Berlin. Thanks a lot to Caroline for this sharp analysis of how the closing of the border in Europe has had tragic repercussions in the Horn of Africa. So I would be interested in hearing how much pressure do African NGOs or African governments get from the European Union to kind of keep migrants in sub-Saharan Africa? If you have any insights from your own work, or whether you discuss these issues with colleagues, and will it be possible for African NGOs and governments to resist this pressure from Europe? Thanks.
Okay, David, you probably...
Or should I answer?
No, I think we should answer these two, right, because we have to go on after that.
Well, there was one question for me. In fact, I had another slide prepared, which I skipped. It was behind the last slide, looking a little more into that question, because we're currently at SWP working on this issue, and there are numbers, even though they are they're just a snapshot. They're not detailed enough. But if you look at the 30 countries worldwide that are hosting the most refugees, I think 2/3 of the, if you look at the financial resources that are used in this context, 2/3 are from domestic revenues and 1/3 is from international resources, and a very small percentage, only 2%, is official development aid, and I think 1% is humanitarian aid, not to talk about peacekeeping, which is even less. So it really depends on the context how the financial resources that are available to refugees and the host communities are being used. In Yemen, for example, 50% of the people depend on remittances. In Afghanistan, 50% is being funded by foreign actors. and foreign aid. So I think looking more into this is really also important within the Global Compact for refugees, since this is, if there's no willingness to resettle people, at least the financial part should work better than it does right now.
Caroline?
Thank you for the questions. I would like to refer the colleague from Save the Children to a very useful data collection analysis tool that has been developed by the Global Mixed Migration Center, which is hosted by the Danish Refugee Council. And that was the first tool that made us aware of the very child-specific concerns on the migration routes, but also in transit and in countries of destination. And what that tool does is that it has deployed a network of monitors that speak with migrants on the realities of their migration journey, and it also records the ages of the migrants. And so that has brought in more actors that are doing child-specific protection, like we have Caritas, SOS Village, and also most recently, we've also had Save the Children getting very active in the Horn of Africa. Of course, UNICEF is there as well. But the conversation, especially with governments in the Horn of Africa on child-specific protection in the context of migration is still missing, and I think that is something that we need to have. On what pressure exists, it's for governments, it's for civil society actors. Just before Valletta, in the region, we had what is the European Development Fund as a funding tool for development action. So we had gone through the approval process and money had been allocated for development. Valletta happened and the EUTF was announced, but remember it's an emergency fund, so it's not development. And what happened was that the resources meant to be provided to EDF under the European Development Fund were put into the EUTF. I mean, these two are different. You cannot address, there is long-term development, which should be addressed with very specific tools, as has been agreed by European and African countries. But the reality was that there were no resources to manage things like biodiversity, social service provision, etc., because suddenly all those things had to be looked at from a migration angle. And that brings us to the reality of conditionality of development aid, which is being linked increasingly to migration. And a colleague of mine who worked on fisheries asked me, Caroline, how can I make it possible to link fisheries to migration? And I asked, what do you mean? He said, that is where the money is, because the budget that had been allocated for fisheries was no longer there. And I couldn't really provide an answer, but he was very creative and came up with a presentation that was presented to the local EU delegation that started with a salmon migration. And so that speaks to the pressure. You have to link education to migration, health services to migration, almost everything to migration. And what is happening is that actors are getting creative on how to do that so as to access money. Of course, the results of it will not be what we are looking at. So in a nutshell, that's the kind of pressure that is currently happening. But I mentioned in my introduction, Michael, with your slight indulgence, that it's not just that there is this push to link development or attempt by European partners to link development financing to migration. The African states themselves are playing the game. So they're saying, okay, we are talking about return of people. They say, that's fine, our people will take them back. But we need so much money to take them back, to take our own people. And the money is in millions for return of 15 people. I mean, if you ask me, it's really outrageous. And it's not also straightforward. They keep sort of almost playing a game and pushing these for as long as is possible and trying to get the money. So that, I mean, this is something that we really need to step out from. Establish clear means of how do people return, because, I mean, people will have to be returned when their asylum claims are not successful. But how does that happen? And not sort of have under the table dealings with African governments as well. Thank you.
Thank you very much to all of you. And now we'll move on to the future of Schengen, die Zukunft von Schengen.